everybody, thank you for taking the time to be here today. And wanted to go over some changes that have taken place. And kind of the main gist of what we're going to do today is to make sure we're doing everything we can to avoid conflict, claims, and litigation. But let's go through. I've got a couple announcements, some things to make here. So I think everybody is right now, but if you would please just mute your microphones, and we can turn those on later if we'd like. Okay. All right, got more people joining. All right. Just a quick disclaimer. Our conversation today, not legal or tax advice. You can read the rest of the disclaimer there if you'd like. And these are the topics we're going to cover. So it's quite a bit, but we're going to go through and I'm going to just try to highlight the top level concepts, ideas for all of us. Again, kind of the whole idea here is just avoiding conflict as we're going forward in this already changed market. A couple of announcements to make. Wanted to say congratulations to our top producers from last year. Lewin Potts, who's been doing great, having a fabulous couple of years. Vicky Ebisu and Harrison Luke. Tu Nagata, also having some really good years. And then Jay Boris broke into the top producer level this year. So congratulations, Jay and everybody else. And our number one company top producer, Aaron Lynn. Aaron's just been doing great. Gangbusters out there, doing a lot of business. He's also been helping some of the younger agents. We appreciate that. He's helping to mentor some of them. And I don't know if you saw this write-up about Aaron and PBN, but besides real estate, Aaron is also an investor in a couple of different tech companies. He has probably the best virtual staging company in town. If you ever need those services, make sure that you reach out to Aaron. And he also founded a group that helps collegiate graduates with their career paths. And he is helping to coordinate career nights, etc. So Aaron, thanks for all that you do for everybody. And congratulations being the number one top producer. The biggest congratulations goes to everybody. We are one of the few firms, if not the only, that's appeared on all 4 of the top 25 lists for Pacific Business News. And in the last rankings, we are the 10th largest real estate company on Oahu, and that's ranked by sales volume. That's a pretty amazing feat. Number 17 in the state. So congratulations to all of you for everything that you do every day. It's quite an accomplishment. I think you know, but we have these 2 marketing tools available for you. The info market graphic we do every month usually comes out around the 7th or the 8th, just after the Board of Realtor statistics comes out. This is great for social media, for any type of e-marketing that you're doing, for your website. You can grab that. And you can see it's a GIF file, so it has a little bit of movement just to make it interesting. And the other one is every month we're doing the Hawaii Housing Report with Paul Brubaker. It's a fascinating conversation with him to be able to get his insights, to see what's really happening out there. Hopefully you've all been seeing that, but it's also another good marketing tool for you that you can use with your clients. If you are interested in doing some custom market pieces of some sort, as you know, we have a whole suite of things available on the toolbox. But if you're interested, there's 2 sites you might want to check out. The first one is Fiverr.com. If you've been there before, it's kind of interesting. You can hire graphic artists from around the planet, everywhere. And they'll give you the prices, the quotes for prices. There are things you can do on Fiverr for $10, $15 that would cost $300 or $500 if you have a graphic designer here in Hawaii do it. But if you're interested, check it out. Very, very, very cheap rates. And it's, hit or miss. You got to kind of experiment a little bit, but it's kind of an interesting spot. The other one, if you're feeling a little more creative yourself, is Canva.com. Canva has a free account that you can sign up for. They also have a paid account, and there's templates that are completely done for you, and you can just drop in your information. But they're good. They're good quality templates and design. So if you want to kind of take a stab at things yourself, take a look at it. As always, with all these things, before you go out and use them in public, please send it to me so I can review it for compliance. And this is the requirement for all marketing pieces, and I think you know this. Number one, Hawaii Real Estate Commission says you have to have the company name on the advertising. And you don't have to really have anything else, but that's the one that has to be there. If your name is used, it has to be your license name, and you have to have the R or the RA after your name. The license number is actually not a requirement right now. It probably will be in the future, but it is not a requirement right now. But I think to prepare, we're putting that on most of the pieces that we use. Now, marketing includes all the obvious ones, but I want to remind you, it also includes your email signature. So sometimes I will get an email from you, maybe off your phone or off your tablet, and it doesn't have the required information. So make sure that that's on there. It's also required for social media posts. There's different ways you can handle it, but just make sure you comply. Has to have that company name on there. And if you use your name, needs to be legal name with the R or the RA. Okay, these are some interesting topics that have come up. This first one is something that I've learned for the first time. And I called many of the top brokers in town at the big companies who were unaware of this. I would say it's a little bit of a work in progress as far as getting the information. And I'm working with the Honolulu Board of Realtors to get a little more clarification. But in essence, what it is, if you're selling a property that is a short-term rental property, or if you're representing a buyer, sometimes owners will move into those units, and to get a better tax rate, they'll convert it into an owner-occupant unit. According to the tax department, in order to do that, they have to sign a 5-year restrictive period. So someone buys the Hawaiian Monarch. They want to move in, they change it to an owner-occupant, they're going to get the lower tax rate. If they sell it the following year, that 5-year restriction remains on that property. And if any future owner does a short-term rental in there, they will be charged all the back taxes plus penalties. So what happened to us, it was at the Hawaiian Monarch. We represented the buyer who bought from someone who had owned the unit for a year, and that person was using it for a short-term rental. That person bought it from someone else who, unknown to everyone, had turned it into an owner occupant and committed to this 5-year restrictive period. Our owner had been renting the property out, no problem. They were audited by the tax department, and it was maybe 3 or 4 months before the end of this 5-year restriction. They have been hit with all the back taxes plus penalties. So my advice to you, if we're selling something in these buildings, you need to check this to see if it applies. So how do you check? And here's where it gets really weird. This does not appear in the tax records anywhere, and the tax department does not put any sort of documentation on the title. So it's impossible to find if you search the tax records or if you look at your title documents. The only way is to call the tax department. The guy that I spoke to multiple times was very helpful, but he himself kept saying, it's so ridiculous. No one knows about this, and there's no resource to go and find which properties apply. So again, you're selling anything in these short-term rental buildings where there's a possibility that there was tax change at some point. The only way to do it is to call the tax department. And you can call me and we can talk about it. And I have this person's contact info. Okay, second one, short-term rental disclosure statement. This is the DPP form. We're all familiar with this. It's required for all properties, all residential properties on Oahu, and everybody's been using it. Technically, it's to be signed before the buyer signs a purchase contract. That's why many of the companies will insert this into MLS, and I recommend you do the same. If you're the listing agent, put it in the supplement section. We've also been attaching it to the purchase contract just to make sure that this is something that is done, signed, and documented. But here's the issue. It says if the seller checks box number 1, which says that it is a legal use, then the seller has to provide the following 2 items to the buyer prior to the execution of a purchase contract. The first one, you can read that, is the applicable government permit number. They go on to describe some other things. The second one is tax certificate, clearance, like blah, blah, blah. I'm selling a unit at Ritz-Carlton. There is no applicable government permit number. So I called DPP. They're very helpful, very friendly. And they explained to me that although the form says this, for things that we might consider to be short-term rentals, this doesn't apply, which doesn't make any sense, but that's what it is. So when I spoke to him, I said, how do I comply with A? He said, there is nothing. Your property is resort zoned. It's a hotel, so you don't need that. How about B? You don't need that either because it's resort. So I said, how do I fill out the form? And I go back to the form here. What do I send you? And he said, I don't think you really need to use this form. And it's that doesn't make any sense. But my point is, if you have any short-term rental and you're dealing with this and it is a legal short-term rental, call DPP to confirm what you need to insert here and what needs to be used. Okay. And if there's any confusion, you call me, we'll have a conversation and we'll figure it out. Okay. Minimizing conflict, complaints, and litigation. I've tried to collect a bunch of war stories throughout the past year, both within our company and things I've heard other brokers talk about, and kind of highlight some of the bigger issues that have been coming up, and then talk about maybe some strategies that we can avoid all that. And we are in a transitioned market. We're not transitioning anymore. And perhaps in this new market, there might be an increase in these types of issues. We want to make sure that we're doing everything perfect. These are the top complaints compiled by the Honolulu Board of Realtors and the Hawaii Association of Realtors. Good old property management tops every list all the time, but luckily we're not doing that. Some of you are doing it for your personal properties. You have to be really, really careful. This is the #1 area of litigation across the board in real estate. You can see the other issues around agency and non-disclosure, and we're going to talk a little bit more about that in a minute. These are the top complaints compiled by NAR. So misstating material feature of the property, termites, which is a big one for us in Hawaii, condition of the roof, and the boundary properties. So we're going to look at these also a little bit more detail. This is the top from the DCCA and the RICO filings. Again, good old property management at the top. Failure to disclose material fact, dual agency, unlicensed activity, aiding and abetting unlicensed activity, fraud, and untruthful renewal application. Okay, and then finally, this is from our errors and omission insurance company, the providers. #1, property management. 2, misrepresentation, failure to disclose, and negligence. And in this case, negligence referring to agent negligence. So I've broken this down into 3 big categories, and we're going to look at some of the issues that I've seen over the past year. Let's start with failure to disclose and misrepresentation. I'm just going to lump those together. AOAO updated docs and notices. I think a lot of you do this. If you're not doing this, whether you represent buyer or seller, during the escrow period, there can be updated documents that are issued. Prior to closing, wherever you've ordered those documents, or talk to the management company, find out, has anything been updated, new notices gone out. Our sellers need to be very diligent. If they receive anything from the AOAO, they need to send those to us. We've been in multiple situations where letters, emails have gone out to owners notifying them of something material, like a new special assessment coming up. The owners claim they never received it. The buyers move in, closing. Now they find out, no, they've been telling the owners this for a month. So make sure you're doing it on either side, buyer or seller. Find out if there's any updated documents. Termites, huge. I know many times you're submitting purchase contracts to me and saying, well, the buyer doesn't need a termite report. They're either going to tear it down, or they want this offer to look really good. I will always tell you to put that back in. It's such a big issue. In a tear down home, yes, there might not be any flying termites that you care about, but if there's ground termites, that's a whole nother issue, and that should be found out through an inspection report. So let's try to never take that out. If the buyers want to have a more acceptable offer, they can either pay for the termite inspection report, just check the box, or they can reimburse the seller at closing. Condition of property and roof. I think every deal we're doing, we're having a home inspector go in there. The roof is something that some of them do, some of them don't. It's another area, another important area, whether you're lister or buyer, to try to do a little more due diligence to determine, are there any issues with the roof? And some of the property inspectors, like I say, will inspect that as well. And I think those are the guys who we'd like to use. Property boundaries. Similar to termites, many times offers are coming in and this is being taken out and saying, well, we want it to be more competitive as a buyer's offer. Don't take it out. Boundary encroach or property lines are so important. And although you may think you know where it is, it might not be there. So when this case comes up and if someone says, I don't need it, yes, you do. Especially if you're a seller, you don't want that liability hanging out there. So let's leave those in. Okay, negligence. The biggest thing that I've seen inside our company and outside our company is missing important timelines in the purchase contract. And we're going to look at some of those specifically, but this is the biggest issue. And I see it also with agents on the other side of our transactions. We're going to talk about some of those in more detail, and then giving incorrect advice. I don't think we do that too often, but I appreciate everybody calling me if there's any question about anything. And this one, aiding and abetting unlicensed activity. Just to remind you, it's illegal against the law to pay any individual person, including a licensed agent. We can only pay fees to a licensed company, and those fees can only be paid by a licensed company. So you as a licensed agent should never be paying any individual any sorts of fees related to a transaction, CPAs, attorneys, etc. We had an issue several years back. One of our agents, unknown to me, had paid a CPA in cash for a referral that they received. And I think the amount was like $2,000 or $3,000. Something happened later on, and the CPA came back and said, I want another $5,000 or I'm turning you in, and I have all the evidence. When we found out, we had to release that agent, but that is illegal. It's criminal activity. So don't do it. If you ever have any questions, give me a call. We can figure it out. And I will say we can pay companies outside the state of Hawaii, but they have to be a licensed company in their country or in their state. All right, these are sort of the common causes, let's say, of conflict and the things that I see come up. The first part is poorly written agreements. Inclusions and exclusions. If you are purchasing a property for your buyer and there's 2 washers and dryers, say that there's 2 washers and dryers in the purchase contract, or there's 2 refrigerators. If your seller wants to take the dryer, make sure that that's in the exclusions. We've gotten into so many arguments about that in the final hours of closings. Just be really, really thorough in what's going in there. The closing date, we generally say 45 days after acceptance date. That's fine, or a hard date. Do not use 45 days or sooner. And I'll tell you why. We had an issue years ago. That's what it said in the purchase contract, is 45 days or sooner. Seller lived in the property. They're preparing for the move. The buyer, who's a Japanese buyer, said, I think it's 2 weeks or 3 weeks before closing, okay, let's close. And we said, well, no, it's 45 days. And he said, no, or sooner. And I want to do it or sooner. So leave that off. I know it sounds silly, but these are the things that happen. In credits and reimbursements, just make sure everything is in writing. The second thing is deviation from the written agreement. J1 is the best example. So J1, if you have 10 days from acceptance date for J1, there's no approval of J1 that's needed. On day 11, it's accepted, nothing has to be done. If on day 10, on the last day, you're frantically writing to the seller, we want this repaired and you got to do this and sign that. And the other agent saying, yes, we'll sign it. And they don't. And it's now day 11, J1 is accepted. Many times on both sides of our transactions, other side as well. Agents don't understand. And they're saying, no, but I wrote all of this that the seller had to repair. It doesn't matter. It's accepted. J3, final walkthrough, same thing. If it says 4 days prior to closing for the J3 walkthrough, that's the last day that you can do it. By the way, you can do it on day 5 or 6. And then an agent goes in on day 3 because the seller wouldn't provide access on day 4. J3 has already been waived. It's gone. You can't use that anymore. So it's so important to follow the written agreement and those dates. And then finally, H4, the financing contingency, which we're going to look into more detail because that one is maybe the biggest issue that comes up. Misinterpretation of the written agreement. This is going to tie into what we're going to talk about in a moment, which is the termination under a contingency, termination O-2. And then finally, the killer of all killers, verbal communication and negotiation. Just don't do it. You already know this, but no verbal negotiation. We don't engage in that. If you're a listing agent and a buyer's agent asks you, I know it's $1 million, will your guy take 900,000 and let us know and then we'll submit an offer? Your answer is, I am so sorry, we do not engage in verbal negotiation. If your buyer's interested, submit an offer. If you're working with a buyer and you submit an offer and the seller's agent says, hey, we got your offer for 900, will your guy take 950 and we'll counter? You have to say the same thing. We do not verbally negotiate. Please give me the counter. We'll take it from there and see what happens. Do not get involved in that. I've told you all the war stories before of things that can happen, but so important. And this one, if it's not in writing, it does not exist. I can say in the last couple of issues that we've had to deal with, complaints and other things, our agents have done an excellent job in this area. Back up everything in writing. Just have that email trail, especially if it's something important or potentially controversial. Just make sure every single thing is in writing. And great job. I think everybody's been doing that really well. Okay, the danger. These are the 3 things that have come up in the past year. Purchase contract dates, talked about it already. We're going to go into a little more detail on it, but so important that you're tracking those once you're in escrow. Complying with the financing contingency. I want to talk about that a little bit. I don't know why this still becomes a problem. And under the new purchase contract that I'm working on with the Standard Forms Committee, we're going to address some of these issues to hopefully make it more clear. And then the seller non-disclosure, just be sure you're telling your seller anything bad, they've got to put it in there, and anything that you find out that potentially could be bad about the property. And I'll make a comment here. 508D, which is the statute in Hawaii that talks about seller disclosure. In 508D, it says a material fact must be disclosed. And in 508D, it goes on to describe a material fact is something that physically affects the property. So a hole in the roof would be a physical issue. A murder-suicide in the building or in the unit would not be a material fact under the statute. However, we must also comply with common law, and common law are the court cases and other types of things that have come out. Under common law, I think we would all agree in the layman's terms that a murder-suicide in a home would be a material fact. So from our perspective, as a company perspective, we will disclose notorious acts such as that, murders, deaths, major crimes, etc. Okay, so best practices, we already talked about this, but just absolutely no verbal negotiations. If there's anything that you do talk about, then you're going to follow up all communication with an email, have that paper trail. It's not in writing, doesn't exist. And then read the purchase contracts. We've got a little bit of free time on our hands right now. Things have slowed down a little bit, especially H3 and H4, the financing contingencies so that you clearly understand that. We're going to look at a few of the sentences out of there in a moment. Obtain the updated AO documents before closing. I always like this saying, be the source of the source, not the source of the information. Someone says, how old is the roof? Instead of saying the roof is 20 years old, say, according to ABC Roofing Company, whose number is 808-101, the roof is 20 years old. You can call them to verify. Be the source of the source, not the source of the information. Disclose in writing. I know that you all know that. And then this, if I would say the number one takeaway from today is use the escrow timeline sheet once you're in escrow and review it every single day. We have this one, which is available on our toolbox. This is the one that I use. I review it every single day, and do not rely on the escrow coordinator. We've been involved in two things in the past year where the answer from the agent was the escrow coordinator was supposed to do that. No, the escrow coordinator there is there to help, but you've got to look at the timelines yourself and track it, make sure everything's getting done. Also, the escrow coordinators all prepare a timeline. Don't rely on it just because they prepared it. Go through and look and check the dates. There was one escrow timeline that was prepared by the escrow coordinator, and she had all the days were one day more because she didn't understand how to calculate the days in the purchase contract. So escrow coordinators are great. Just make sure you're reviewing your timeframes every day and make sure everything's being taken care of. Okay, let's move into the cybersecurity and wire fraud. I think everybody's pretty familiar with this issue. This was a really good cybersecurity webinar, if you happen to catch it. If you're a member of the Hawaii International Real Estate Council, this is a free webinar. There's video replays. And by the way, if you're not a member of the Hawaii International Real Estate Council, consider joining. It's only $30 for the year. There's a whole bunch of webinars like this that are absolutely free. Guests pay $20 to attend. And I can't believe guests are still coming to all these and paying $20 rather than $30 and just joining. But if you sign up for the Hawaii International Real Estate Council, you get free access, plus you can see the video replays. So I'll plug that little commercial as the president of it. So let me know if you're interested and join up for that. I know some of you are already. But in any event, this gentleman talked about a lot of things. A lot of it just scared me, quite frankly. But there's a couple issues I wanted to talk about. We get targeted with this text all the time, right? As realtors. No one in our company, I am never going to do it. No other realtor is going to ask you to go get money or gift cards for them because they're in a meeting and they can't do it. Never going to happen. And I'm never going to text you from Europe and say, I'm stuck in a hotel. Can you wire me money? It's not going to happen. We are so targeted because our information is so available. And these criminals are no longer just some kids hacking away in a garage. These are governments. These are funded scamming devices. So they go in, they can become very sophisticated in the messaging and the way that the text look. The best thing to do if you get any of these and it looks a little suspicious, throw that away and just call the person direct. I think everybody knows that, but I just want to remind you, no one's going to ever ask you for money in a text. The fake rental ads. So this has happened multiple times with properties. And I remember years ago in our office, a family flew in from Australia, mom, dad, two kids, to get their keys to go to their rental unit. It was a scam. Had nothing to do with us. The poor people. So we helped them get a hotel. I don't know what happened to them in the end. But what the perpetrators are doing is they see your listing for sale in MLS. They're stealing all the pictures, they're stealing all the data, and then they're throwing ads up like this in Craigslist. This just happened to Terry. Terry got a call from someone that said, hey, I noticed you're also selling it, but I'm renting it. Is it okay that, I'm going to be there while you're selling it? And she said, no, that's not for rent. She found the fake rental ad. It was on Craigslist. So here's a strategy that you can do when you list a property. If you've never used Google Alerts, just go to google.com/alerts or just type in Google Alerts in Google. It'll get you there. You can type in anything that you want. And what Google Alerts will do is tell you every time that something appears online related to your topic. You can put your name in as an example. But what we're talking about here is you put the property address in this Google alert. It's going to let you know if suddenly something popped up on Craigslist. It will help you. If it's something on Craigslist or on most of these legitimate sites, you can let them know and they will actually take the ad down, that it's a fake ad. But it's worthwhile. After I heard about this, I've been doing that for my listings. The cybersecurity wire fraud issue, again, I think probably you've already heard about it, but it is rampant right now. The biggest thing is wiring instructions between escrow and the clients. Here in Hawaii, we had a really big one. It was a $3 million wire coming from Japan. The buyer, who's in Japan, received an email from the escrow company saying, oh, sorry, our previous instructions were wrong. This is the correct codes to send this wire to. The person in Japan said, great, they sent out the wire. Luckily, the brokers and the agents determined something had happened. It's a day later, 24 hours later. Found out that the funds, when they're coming international, have to sit in the US for 48 hours before they're transferred. They were able to catch it and stop this from going out. It was going to go to Romania or something like that. But it took about 6 months to get those funds back. The bottom line of all of this is it's happening. Clients are being targeted every day. You've got to let your sellers know and you got to let the buyers know, because generally that's how these funds are going back and forth. We have a brand new LHI standard addendum. It's down to 1 page, no more 2 pages. So we've taken some things out, but we've put some things in. This is the disclosure which is found in the purchase contract, but it's kind of buried in the back pages and I-6 additional disclosures. We're going to put this wire fraud alert right in the front of our addendum as the number 1, just to put everybody on notice to see what it is. And I want to point out one line in here, which is the last line. Agents with luxury homes will never send wire instructions to any party. That is true. You should never, ever, ever be involved in the wire instructions. I have a deal that's going to close shortly. The sellers just emailed me their bank account and their wiring instructions. I deleted all of it. I called them and I said, do not send that to me. I can't forward that to escrow. That needs to be between you and escrow directly. And as you may already know, escrow will always verbally verify the account numbers prior to wiring. And if there's any change, we recommend that the seller or the buyer call a trusted phone number that they knew before, not us, to call escrow to verify. But main thing for all of us here, we stay out of that 100%. That's between the clients and escrow. Oh, this is also on our standard addendum. This has always been there, but I just want to point out why you see it here and why you see it on many other standard addenda. The professional property inspections and protection plans. This is a requirement of our E&O company that we put this on here. I would highly recommend, and I think most of you do already, always get both of these, professional inspection and the protection plan. The protection plans are not that expensive. If you want to give it as a gift, you can, but if not, just have the buyer buy it themselves. I closed on a Manoa property a little while ago. 2 days after they moved in, the water heater broke. Yeah. It was so great to say, don't call me, call the home warranty. And they're happy as can be. And other issues came up, but along the line, it just kills it right there. Instead of getting into a non-disclosure issue, the seller knew about it, all that sort of stuff. Highly, highly recommend that you go for the home warranty programs. And there's been a change. Some have pulled out of Hawaii, but I have a list of what we've been using anyway on our toolbox. Okay, these are some new releases from the Standard Forms Committee, and I thought I would go through a couple of these just to let you know. This is the forms. You can see some were revised, and there's a brand new form, which is the notice of termination. So this is the notice of termination, a brand new form, and it may look familiar because it's actually fashioned on the one we've been using. And this does require broker review anytime you're talking about termination or any sort of um, uh, default potential. Make sure that you call me. We have a conversation. It's pretty simple to complete, and there's only three options here: termination due to default within a contingency period, and then the O3, which is also within a contingency period plus a few days. The revised cooperating brokerage separate agreement. This is the new box that you'll see. Box number 6. This is the new one that's being used right now. And if we close up on that, you'll see that the W-9 is no longer an option, that it will be given to the listing agent company. And also, the general excise tax number will be provided to the listing brokerage firm. This might sound familiar to you because I've been asking you for these for the past year. And this is the section in our close sale checkbox. So what I've highlighted in red here, if the buyer is represented by another brokerage firm, then you need to complete this area, this section here. The reality is we can get the GET number online. It is public information, but it just makes it so much easier if the brokerage firm will fill it in. Why the change? There's two philosophies on how the tax reporting should be done right now. And I don't have a definitive answer. I'm not a tax expert, but we're going to collect all this information so that we'd be able to comply with either way. The extension of closing date, which is a modified form, and I've just underlined what they put in here. It's just reaffirming what you already know about F3A. F3A is that unilateral extension. Once it's used by either party, then it's done. Cannot be used anymore. So this is just put it in there just to make it clear. I guess there was some confusion by some people. The revised seller's disclosure statement. One thing I would say on this, and we've been working on it for the past year, is trying to get this into a fillable format. And you can't believe how difficult it's been with zip forms. But we're working towards it. Hopefully in a couple months, we'll have that out. So it'll be much easier for sellers to complete this when they're doing the form. Just want to point out a couple things. This is not new, but the sea level rise exposure area, this is in the box that we can complete, that first box. It does need to be completed for every transaction by the sellers. And then I've kind of screenshot from our toolbox down below. If you're unfamiliar with it, you can check. There's a little video there and some information, but you have to look at that 3.2 feet and see if the property falls into that sea level rise exposure area. And it can be very different throughout Waikiki. Ritz-Carlton is not, the one across the street is. So you have to kind of scroll down there. Best practices when you go on the site is to take some screenshots. I throw those onto an updated disclosure that I attach to the seller's disclosure statement. Okay, these are some changes to the seller's disclosure statement. There's a new question in there about tree roots causing damage. So just to be aware that it's in there, and be aware of your properties. If you see it, if it's obvious, you're responsible as well. The abandoned wells on a property. This is not so common for us, but this is a new law or statute that was passed by the Hawaii government. If there's any abandoned wells on the property, it has to be disclosed, and then there are some things that have to take place afterwards. The place we would see this most often for us would either be North Shore, some of the places out west. But just to be aware, again, as a listing agent, to ask the seller if there are any abandoned wells that they know of on the property. And then in section B, there's a couple things that have been added. Gas or propane, as you may know, some places have propane, but there was no section for it, so that's in there. Then the trash collection, is it available, and recycling, green waste, you can see that down below. And then section B, this is also some additional and some modifications. Has there been any evidence or presence of any pest? I'm not sure how you answer that. I think here we live in Hawaii. The answer is yes, there's something, right? The word infestation, which was previously used, also couldn't really be uh, determined what it meant. So when it got into litigation, both words are not good. But I think probably the best answer is yes, I live in Hawaii. The next one should maybe give some light to whether how bad it was, but if yes, has there been any treatment? And then the next one about the wood destroying organisms, and I'll point out in there, it also has the powder post beetles, which sometimes you do find out on the west side in some of the dry rot. But again, this is added. Has there been any treatment that wasn't in there previously for the termite? Okay, new sight unseen addendum. This one's kind of cool. So you've got someone who's buying, they've never seen the property. This is now a requirement that will be attached to that property. I heard a lot of war stories while we were working on the form from the other brokers, and there were two cases that were very interesting to me that revolved around the smells at the property. Someone bought sight unseen, and there were bad smells for whatever reason. I think there was a little canals or something that ran by there. The other one was the sounds. They're very subjective, but that's why we're going to put this, or why we're using this now, this sight unseen addendum. So anyway, just another tool for everybody. I want to make you aware that it's there. All right. Okay. Going to point out a couple things in the purchase contract that relate to what we've been talking about and kind of go into it in a little bit of detail. Our goal as a company is to be 100% correct 100% of the time when we do our purchase contracts and really be an example for our industry. So when to submit a purchase contract or counteroffer? As soon as possible, because there is a rescission period, as you know. We just had this case happen. We received an offer. We're the listing agent. We received an offer for a property, and whatever it was, the seller countered. And the counter was maybe 50,000 less than the list price with financing, but it was okay. The seller signed the counter offer. We delivered it to the buyer's side in the morning. 12 noon, we get a full price, all cash offer, 21-day close. Seller says, what can I do? The buyer had not sent it to us. They did not accept it. So we had the seller rescinded the counter offer to the buyer. The buyer's agent called panicking, saying, oh my God, the buyer signed it this morning. I just never sent it to you. It's too late. If they sign it, it needs to be delivered. So I felt terrible for the agent, but that was on them. So if you have a contract, anything that's signed, just get it out as soon as possible. And I really try to make an effort when you have a counter offer and you send it to me, I really give that a priority because I know that the timing is kind of hot. Okay, terms that cannot be deleted. These cannot be deleted from our purchase contract. Section 1, seller's disclosure statement. Statutory, you can't take it out. J1, cannot take it out. There's no box to let you take it out. That's why. And then M1, the mandatory provision of documents. This is statutory. It cannot be taken out. I hear the same thing. I have my buyer wants to be more attractive, so we're going to not do a J1 inspection. No, we're going to do a J1 inspection. They could do a quick one, but we are going to do a J1 inspection. And just to be clear, the inspection is not just physical inspection of the property. It's everything else as well. So just want to make you aware of that. And if we look at the M1 documents, these cannot be deleted. And this is a seller's obligation. So if you are a seller and your seller says, I don't want to give you these documents or whatever, it is their obligation by law. They must do it. What about the person who says, I already live in the condo building. I don't want it. I don't need it. No, there's no provision for that. They have to be provided. And if you are a seller, you do not want to take on the liability for this. Also, remember, M1 applies to single family homes as well as condominiums. It's not just for condos. Okay, terms that should not be deleted. The final walkthrough. Don't ever delete that. It takes away so much power from the buyer. It affects so many of the other terms in the purchase contract. So that should never be taken out. The survey, we already talked about it. It doesn't matter how well they know the property, unless there's a survey that's recent, right? We can use one of those, but the survey should always be in there. And by the way, when the survey is done, as it sits right now, it doesn't require the staking to be verified. There's a staking up above, which we don't select. That's a very low level. But the survey, when it's done, it's good to be there to verify with the surveyor where exactly are the stakes and ask them to put it in. And then again, the L2 termite, we've already talked about that. These are the big area of litigation. So don't take out the termite. Just the seller or the buyer can pay for it or reimburse the seller. Okay, this is the thing I was talking about when we're misunderstanding the purchase contract. If we're terminating under O-2, so here we're looking at the financing contingency, which is H-3. If the buyer is going to terminate, they terminate under O-2. Now here's the thing, O-2 can only be used, but you have to, or should, can only be used when the delivery to the other party is done prior to the termination date. So the financing contingency does not just say, hey, if you don't get any of these things, you can terminate. No, you have to terminate prior to the expiration date. And if you don't, you can see the next red line down below. If it's not terminated by that date, it can no longer be used as a reason to terminate the purchase contract. So if we look at, we go back to this H3, right? And if we drop down to H4, buyer to deliver to seller by conditional loan commitment letter based upon 1, underwriter approval, and 2, property appraisal. If you don't have those 2 by that date, you have to terminate under this contingency. What happens is somebody says, well, the underwriter says it's okay. The appraisal is good. It was done yesterday. We don't have it yet. If this date goes by and these people cannot get their loan, they cannot terminate under O-2. Therefore, they cannot terminate under the financing contingency. This has come up so many times. We've been on both sides of this thing. Buyer loses their deposits, period. So make sure you're watching these dates, especially in this financing contingency, which seems to be an issue. Okay, so we've kind of talked about all of these bigger issues and some strategies for you to deploy to hopefully not get there, not end up in those spots. Okay, we got a couple minutes. I'm just going to do a quick market update of what's happening out there. Mortgage rates, I think we all know, right? This is in the past year. We're just over 6, or 6.4 right now in the 30-year fix. All the economists keep saying it's going to level back down around 5.5. When? Nobody knows, right? But the bond markets are keeping it up in this rate. And if we look at, this is going back to 1972. We look back to 1972, draw a line like right in the middle of this thing, the rates are not that bad. They are for us because of what we've just experienced, right? Coming off of these rates, and now we're at these rates, but it probably will taper off as the year progresses and into next year. So hopefully that'll be good news for us. This is the Board of Realtors statistics that were just released, and if I'd point out a few things, this is the big number. Closed sales, as we're all feeling it right now, right? Down almost 40%, both condos and single family homes. This is the year-to-date number compared to last year. So this is the bigger number. You can see single family homes. Last year at this point, we sold 1,253. It's at 767. And we're experiencing the same thing internally with our company. It's about 40% off. Active inventory for single family homes. There are more homes on the market right now than there were this time last year. And you can see the number. Last year, 395. There's 535 right now. There is more inventory in the condos as well. And these are substantial numbers, 35% more, 25% more. I know that inventory is tight. We'll talk about that, but it's a lot more than it was last year. New listings coming to the market, it's less than what we were seeing last year on a monthly basis. New listings coming. And the working idea right now, why that is, there's a percentage, and I've heard as high as 63% of people who own a property right now are locked in at a mortgage at 3.5% or less. If they sell their place now they're looking at a 6.5% mortgage. So they're just keeping it off the market until that rate kind of drops back down and makes that move a little bit easier. If we look at days on market, you can see it's up substantially for homes, 140% from 10 days in April last year to now 24. That's still pretty darn fast, right? And condos selling in 20 days, that's still very, very fast. And here's the month's supply of inventory. Traditionally, we think of market equilibrium when this number is around 4 months of remaining inventory. This means if no more listings came on the market today, based on how fast we're selling, when would all the inventory be gone? Right now, it'd be gone in 2 months. So this is indicative of a seller's market. It's such a strange moment. I know it's a seller's market, but there's added inventory and I'm seeing prices come down, but it's just I don't know where we're at with this thing. It's a mystery right now. If we look at what's coming next month, pending sales are down 26% for home, 33 for condos. This is better than it was a couple months ago, where we were down 50%. It's still, a harbinger that things are not going to shoot through the roof right now, but it seems like there's more sales, there's more deals going down. On the pricing, it's really remained flat. Single family, this is month over month or year to year. We can see 9.5% and 2%. I read it as flat. Out there in the field, you see it. There's still multiple offers on properties, and on some of the less quality, we're definitely seeing price reductions in different things. Okay, so hey, right on time. So I'm just going to wrap this up with some thoughts. Things are slower right now. That's just the reality. So I'm kind of looking at as opportunities, like what can we do with a little bit of extra time that we have right now, other than spend some good quality time with our family. But one is to further your education and skills. I find myself signing up for a lot more webinars recently. I've got a little extra time, right? But it's a really good moment. And if you look at the HBR e-blast that goes out every week, they send that out. There's a whole slew of classes down at the bottom, but a great time to get out there and sharpen your skills. Reconnect with your past clients. Number one source of business for all of us. Make sure that you're doing that however you do it. Expand your database. If you don't have a database, come on, man, get with it. You got to get that database together. Email and first name minimum, so you can do some marketing to them and start to consistently market to your database. They want to hear from you. They want to know what's happening. If you don't have anything else to use the market report graphic and the information that goes out each month. Just change all the information at the bottom and put your contact information in there. And then I know some of you have been doing this. Go out and got some time, go preview the FSBOs and the expireds and see if you can strike up a little bit of a relationship and get them as listing clients, because they are going to list on both of these groups. And especially the FSBOs are so easy to find, and they're so excited when you'll come out and see their property. So take the time, get out there and do it. And host open houses. I've been going to open houses recently, and the traffic seems strong. I know that the sales count is down, but I feel like everybody's out there getting poised, waiting for this moment, for the rates to make some sort of a move. But it's a great time to be out there at the open houses and get ready, because a lot of buyers that are sitting on the fence waiting. They're just waiting for that moment. So everybody, thank you very much for taking the time today. You all do such a great job. It's just a reminder on some of these areas, make sure we're doing all the right stuff. And like I said, next month, we're going to do something in person. I can't wait to see everybody. Now that COVID's sort of over, we can hug, have some fun, and have some laughs. So stay safe, healthy, and happy, and I will see you soon. Aloha. Bye.